The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Good afternoon. We have three cases will be submitted. They are Emily Bass on behalf of herself and others versus J.C. Penney. The second case is in re the interest of J.C. and the final case is in re the interest of R.D. That last case is now submitted to the court without an argument, and we'll hear the arguments in the first case. Mr. Lessmann.
Thank you, Your Honor. May it please the court, counsel. My name is Colby Lessmann. I'm an attorney for Emily Bass, the appellant, along with Tim Bottero, who's seated at counsel table behind me. I'd like to thank the court for allowing us the opportunity to be here today and answer whatever questions you have about our case. We believe our case is an important case today because it is one, we believe, a first impression. It's important to, we believe, taxpayers because it answers or asks the question of whether a taxpayer has a private cause of action against a retailer such as J.C. Penney's when they are believed to have been charged excess sales tax. And one of the things I kind of initially want to point out is, I guess, a factual omission, I guess, that I noticed as we were preparing for today, in that in the briefing of J.C. Penney's, it talks about how my client had made a purchase in August of 2013 and then 6 days later filed a lawsuit. And that is inaccurate. That's not in the record with the district court. The way the record is that was submitted is that in April of 2013, Ms. Bass made a purchase from J.C. Penney's. She realized she had been charged sales tax, she believed wrongfully, on the shipping and handling of her purchase, and the purchase was online, that she wrote a letter to J.C. Penney's in May of 2013, which, as we'll talk about in the statute today, we believe starts a 60-day notice to J.C. Penney's. Within that window, J.C. Penney's did refund her the 48 cents in tax that she had complained about. Several months later, then in August, she made a secondary purchase on the website again. Again, they charged her sales tax on shipping and handling. She believed, again, they've not corrected the problem that I pointed out to them months earlier. And in her interpretation of the statute and through her attorney's interpretation of the statute, we'd already given notice. We didn't believe additional notices were needed every time you make a purchase. And she then filed the lawsuit a few days later. And so I just wanted to point that out because there were multiple purchases. There was a notice given. And our brief says that, but J.C. Penney's brief just kind of starts off in the August and the lawsuit issue. As I was talking about, this is an important case, and kind of the threshold issue, if you will, for the court to look at in our case is whether this private cause of action exists. And in doing that, we look at Iowa Code Section 423.45 sub 2. Under that statute, it talks about how a consumer, if they believe that they have been charged excess sales tax by a retailer, there's a procedure. They are supposed to provide written notification to the retailer to allow, with sufficient information to allow them the opportunity to investigate and respond to the claim, which is exactly what Ms. Bass did in this case. The last sentence of that paragraph states that no cause of action shall accrue against a retailer for excess tax until after that 60 days. Our interpretation and what we've done in this case is it talks about no cause of action for a consumer excess tax, and a consumer has the right to file a lawsuit against the seller if the excess tax issue is not remedied. And so obviously that was the big issue that we had with the district court. J.C. Penney's obviously disagrees with that. The district court disagrees with that. And basically where the district court disagreed with us on this statute is that when you look at, they looked at multiple statutes which are relevant to this situation. Subparagraph 3 of that chapter gives the retailer an option if they get this demand letter, claim letter from a retailer or from a consumer that says, I believe I'm charged excess tax. The retailer has an option that they can remit the tax, refund the tax back to the consumer, which is what they did to Ms. Bass in the first instance when she wrote her letter in April of 2013, or they can turn the money over, remit the money to the Department of Revenue, period. And so our interpretation of that is there's nothing in that section that ties it in with paragraph 2 other than the fact that you have this option to do that. There's nothing that says the fact that you remit this tax somehow precludes you from the consumer from suing you about this or resolving this issue in any other way.
But is there some type of administrative process that's then kicks in at that point then once they remit it to the state?
Well, that's a good question. The statute doesn't say that other than you have a refund procedure under 423.47 that allows not only a consumer the right to seek a refund of excess tax, but JCPenney's also falls within that definition. And so if they remit the tax, which is their option under the statute, it doesn't say there's no cause of action anymore by a consumer against the retailer for charging that excess tax. But both parties do have an administrative right under the statute, under a different statute, to seek a refund of the money. And so JCPenney's wouldn't be out the money if they realized after the lawsuit is underway that, yeah, we've wrongfully been charging people sales tax all the way back to 2005. They could also request a refund. And they could request a refund for all taxpayers that they've charged tax to. Whereas with my client, if she files for a refund under the statute, she's only requesting a refund for herself, which in this case, her sales tax was 48 cents twice. And so I think the reasonable consumer is probably not going to, if they're just talking about themselves, they're not going to hire an attorney and go through the process of requesting a refund for 48 cents when the cost of the stamp is more than the 48 cents. But that procedure is there. But our argument is that there's nothing in the statute, this 423.45 sub 3 and sub 4, that makes, just because they've remitted the tax, that ends our potential cause of action.
But that's a plausible interpretation of the statute, right?
Correct, and we think it's a very logical interpretation because when you look at what the statute says, the statute talks about a consumer's rights against the retailer. And in that
But
same sentence, it says that they...
I misspoke. I mean, it's plausible that where it says the retailer has the option to either return to the consumer or to pay it over to the department, that the paying over to the department was meant to be some kind of a safe harbor that would then force your client to pursue the matter with the department. That's at least a plausible interpretation, right?
Yes, it is. It is a plausible interpretation. In fact, one of the cases that the judge cited, and JCPenney's is cited in this case, the Georgia Power case, we don't think that's applicable, but they had a statute that similarly had the 60-day issue in there, had in there that a consumer has the right to file a claim against the retailer or go to the commissioner. But then their statute explained further that, hey, if you go after the retailer and are unsuccessful, you have to go to the commissioner. Or in the Kawa case that they've also cited talks about 60-day notice window as well, but their statute says that this cause of action is only so long as the tax has not been remitted yet. Our statutes don't say that. And I mean, it's a plausible interpretation of the statute, but the statute doesn't say that.
Well, it doesn't. I guess if it did say it, we wouldn't be here. But tell us a little bit, your view at least, of the history of this statute. It's titled Streamlined Sales and Use Tax Act. And as you know, it arises out of a movement in the law to deal with internet sales and collection of sales tax and kind of what's traditionally been a somewhat difficult area of law for state taxing authorities. And as I examine the history to the extent I've had a chance to do so, it seems one of the underlying purposes of the statute was to, as the title suggests, I mean the uniform title, to streamline the process and make things kind of simple for an internet retailer. So the plausible reading that Justice Mansfield is suggesting is, look, if you collect the tax and you have a consumer complaint, you can kind of refund the money or kind of interplead it or toss it in to the state taxing authority and allow the ordinary administrative process to kick in. And it seems to me, I will just tell you at first blush, it seems to me that's kind of consistent with what I understand the purposes of the streamline Sales Tax Act to be. So I want to give you an opportunity to push back
Okay.
and head me in a better direction.
Well, and I know we went at quite length as to the history of where all these statutes came from in our brief. Yeah, I mean, I think the overall purpose of doing the Streamlined Sales Tax Uniform Act was to try to encourage the retailers to voluntarily collect this tax. Because I think, I know every once in a while I make purchases online and I notice, oh, they haven't charged any sales tax at all on this purchase. And so they're trying to encourage different states to do this, and the states, like any uniform act, have the ability, to change, kind of pick and choose a little bit and change what they want. But even when you look at that Uniform Sales and Use Tax Act, which in our appendix, I would point to appendix pages 101 and 103, it talks about a lot of these, the interplay between the retailers and the consumers. Are we going to give retailers all the rights? And this is solely to protect retailers and encourage them to, just collect the tax and turn it over and no questions asked, or are we going to give some consumers' rights in this as well? And when you look at the language in the act, and there's some recommendations in there, there's a proposed consumer refund policy that's in there. I think that's appendix page 103. Appendix page 101 states one of the recommendations is that to allow a procedure for the consumer to make a claim to the retailer before filing a lawsuit against the retailer for the excess tax. And so even the recommendation under the Uniform Act contemplated that there would be some type of private cause of action. And then in the consumer refund proposal that they had, which is, I believe, appendix page 103, it also had outlined in there the 60-day notice, putting a notice procedure in there, given ample time for them to get information, so that the retailer can properly respond as to whether it's a valid claim or not. But then it talks about, no cause of action against the retailer over excessively charging tax should be allowed until after that notice has been allowed.
Under your interpretation of the statute, which I agree is also a plausible one, there is no safe harbor for the retailer. I mean, the retailer, it could potentially be whipsawed, could find that it's torn, but it isn't certain what to do. It doesn't know if it should turn the money over to the state or turn it back over to the consumer when an issue arises. And doesn't that seem maybe contrary to what you've acknowledged as the purpose behind this Uniform Act, which was to encourage retailers to collect the tax?
Well, I don't think so, because they have a procedure as well, and they were actually told this back in 2011 when the first consumer came forward to them and said, hey, I made a purchase online and there's shipping, you charge sales tax on shipping and handling. You can't do this. In fact, the law changed in 2005. You shouldn't have been doing this since 2005. And so they had contacted the Department of Revenue about what to do and whether what they were doing was right. And they were twice told they shouldn't be doing it. They were once told that they could. And I think it was the first call said you can't, second call said you can, third call said you can't. But ultimately, the third call said, you can ask, you should maybe file a revenue ruling with the Department of Revenue to find out if you're doing the right thing. And they chose to just keep doing it.
And that kind of cuts in favor maybe of the safe harbor business, it seems to me. And just to explore the theory, I mean, the record shows to me, as I looked at the dialogue, and it was laid out nicely in the briefs. I mean, it was kind of confusing, and you're trying to figure out where the knots are, and some of the testimony was a little bit confusing, and it wasn't clear whether they were talking about shipping and handling or delivery charges. And I mean, my reading of the record citations is that everybody seems to be just a tad bit confused here. And isn't that the kind of context that would be alleviated by the notion of, hey, just remit it to the tax authorities and allow the ordinary administrative channel to work? I mean, these guys then are the experts, supposedly, and they're familiar with all their rules and regulations. They have all the informal, all the procedures they have. And doesn't that make the most statutory sense then?
The problem, if the statute is interpreted that way, the problem that it creates is it puts the burden of this issue on the individual taxpayer, which, as I said when we kind of first started, Ms. Bass could have sought a refund, but she's only going to be asking for a refund for herself, over 48 cents. And we believe this conduct is wrong. It's been going on since '05. We're now at 10 years. And so if it's just, hey, we turn the money over, and if a consumer has a problem, they have to seek a refund, she may have been the only one to complain in a year, and nobody else. And so there's hundreds of thousands of dollars, possibly over 10 years, that are wrongfully collected. And so if you put it on the individual taxpayer to raise this issue, it's not going to resolve. They're going to just keep doing it. Whereas if you allow a cause of action against the retailer, and they have to actively do something to find out whether it's do the revenue ruling, to figure out whether what they are doing in fact is wrong, like we claim it is. We filed this as a class action on behalf of all taxpayers. This would be going back to 2005, and they would have not only get an answer to the question of whether their conduct is wrongful or not, but if it is wrong, they hopefully still have all the records for the last 10 years to know who they've charged, who has paid the sales tax, and if they have to do a refund, who they have to do a refund to. Or if it's the class action route, people come forward and say, like a class action goes, and I made these purchases during this time period and try to become a member of the class. But if you find that, hey, if you just let them remit the money and it's up to the consumer, this is never going to get answered. It's just going to be on a case-by-case basis, and I don't think our client, if she was stuck doing that, would have hired an attorney and filed a request for 48 cents. Just the stamp is more, So that's why we think that's not what the statute says, and it shouldn't be interpreted that way because, as the well-settled laws in Iowa, if we're interpreting statutes, we don't want to create an absurd result. And I think allowing that to happen and cast the burden completely on consumers creates an absurd interpretation of the statute. And likewise, I think the district court, they interpreted it as this only applying to a rogue retailer, where a retailer collects sales tax and doesn't turn it over to the state. How often is that going to happen? Not probably very often, and that can't possibly be the interpretation.
Isn't the client's interest the same, whether it's an individual lawsuit or a class action? It requires someone willing to take the time and the effort to bring a lawsuit when they're going to get 48 cents.
Well, correct. What she's looking at for herself is
what's her motivation, and whether it's certified as it's brought as a class, or whether.
Well, she ultimately has an interest, obviously, in getting her refund back. But if it ends up being there'd be an interest and attorney fees, but also just she believes that this is wrong of what's going on, and she wants to try to correct it.
Would her case have some precedents to require that would correct the action as it would go into the future?
Oh, yeah, possibly, because it would, if the court interpreted this as being a private cause of action and ultimately determined that you can't charge sales tax on shipping and handling, that could ultimately affect other retailers out there that are possibly doing that we don't know about. So it could have some precedential value beyond just this case in JCPenney's.
Thank you, counsel.
Thank you.
Mr. Thrall.
May it please the court, counsel. My name is Michael Thrall. I represent JCPenney Company in this appeal. Iowa has long had a comprehensive administrative process to resolve the very issues that are before the court today as it relates to this substantive tax issue. It's a comprehensive administrative scheme that's designed to resolve those and other tax questions and govern disputes between the consumer, taxpayer, and the state.
Well, is this a dispute between the taxpayer and the state? Surely we have the elaborate administrative process for tax matters. But we have, among other claims, some common law claims, and the defendant is not the state. The defendant is a retailer. And the allegation is, at least, that the retailer has made, false statements regarding taxation. So you characterize it, I think, as a dispute between the state of Iowa and Ms. Bass, but the way the plaintiffs frame it, at least, it's a dispute between the retailer and their client. So help me. I understand fully, I think, and
Certainly.
get the notion of the comprehensive tax structure, but what I want you to do is convince me that it applies in this case.
I hope I can, Your Honor. I think the key issue to this is the underlying, or the claims of consumer fraud, the statutory common law claims, as they relate to the collection of the sales tax, cannot be resolved without resolving the underlying taxability question. The California Supreme Court in the Loeffler case, I think, did an excellent job of discussing that. The taxability question really cannot be resolved in the vacuum of this particular case without any input or involvement by the Department of Revenue, the very agency of the state that's charged with interpreting, applying, collecting the tax. J.C. Penney collects the tax as instructed by the state of Iowa, turns it over to the state. It has no role in determining whether the tax is collected under what circumstances. And I think that underlying taxability question is the one that must be resolved as a threshold matter.
I agree with that, I think. I mean, I follow it. However, why not have the department intervene or participate in the litigation between the retailer and
Because at that point in time, you've taken a dispute over 48 cents of sales tax and turned it into a complex litigation. The administrative process, and I think one of the key points, and I cite this in the brief, is that of the 648 claims for refund that were filed, 600 of them are resolved informally. The counsel argues that, somehow the only remedy is to go file this extensive claim for refund. It's a one-page form submitted to the Department of Revenue. If they're right, they're going to get a determination by the very agency charged with interpreting and applying the law. The way this case is developed, they're trying to circumvent this carefully constructed administrative process, bypass that simply by recasting their refund claim as a claim under the Consumer Fraud Act or as a common law claim. And to do so, I think, subverts the whole administrative process. It turns the process by which Iowa sales tax issues are resolved on its head without having the Department of Revenue present. And I think it's important to note the Department of Revenue has not intervened in this case to date. And I suspect, I don't know, but I suspect it's because they already have a process and simply don't want to endorse any efforts to try to circumvent that process.
The problem, though, is that what prevents J.C. Penney or any other retailer from continuing to collect the tax when the department is refunding that tax?
Well, presumably there would be some type of ruling that was issued in some direction provided to the retailer in that regard. As J.C. Penney goes through and collects the tax, it remits it to the state of Iowa. It's not received any direction from the state of Iowa not to collect that.
Historically, it's up to the retailer or the person who has to collect the tax to determine what's taxable and what's not taxable. And to say you want to wash your hands of that duty to determine what's taxable and not taxable and just collect tax and everything and turn it over doesn't do anything for the consumer who is paying this tax in a small amount and then having to go through, and it may not be, 48 cents for a 49-cent stamp. It costs more for the stamp. I mean, to get the refund sort of seems silly if the retailer is not going to be held to some standard about when to collect the tax or not collect the tax.
Well, but the system that you've described has that determination being made with the absence of the Department of Revenue. You're going to have, essentially in 99 counties of Iowa, you're going to have small claim actions. They're going to be resolved differently. There are going to be different interpretations of the tax. You're going to lose your comprehensive, cohesive tax system as it relates to the sales tax because the consumer is going to be allowed to circumvent that process and go outside.
That's why it seems it's better to do it in a class action, let the Department of Revenue come in there and have the question once and for all, rather than 1,000 small claims cases.
Let them sue the Department of Revenue in a class action. I mean, as it stands, I don't have any ability to control whether or not the Department of Revenue intervenes in this case. They have not done so to date, notwithstanding the fact that it's been pending for a number of years now. And I think certainly within the context of this case, we have, and I think there is certainly evidence in the record that the Department of Transportation has provided guidance to retailers such as J.C. Penney and instructed them that if they charge a lump sum delivery charge that is not directly tied to the cost of transportation, they are to assess and collect sales tax, which JCPenney has done, and they've turned it over to the state of Iowa. And I submit under the Streamlined Sales and Use Tax Act, once they exercise that option, which they clearly have under the statute, and turn that tax over to the state of Iowa, that then the consumer's remedy is to file that claim for a refund and to pursue the administrative process. And I think that's clearly laid out in the statute. The Streamlined Use and Sales Tax Act simply does not expressly provide a private cause of action, nor can one be implied under the terms of that particular statute.
Yeah, I might agree with that, but I want to go back to the common law claims. I mean, what's at stake here? I mean, let's get the elephant front and center, at least one of the elephants that I'm seeing. Maybe I'm in the wrong place, but the remedies are fundamentally different. Under the Tort Claims Act, if you seek a tax refund from the state, you're not going to be bringing intentional tort claims against the state because there's immunity. So the remedies that are available in the administrative process are fairly contained. And from the plaintiff's perspective, the common law remedies are more robust. And under your interpretation, it seems to me, the end result is the retailer might be committing very serious fraud even. I mean, the hypothetical might be, well, let's charge them 9% instead of 8%, and we'll just pocket it, nobody will complain. And then if they do complain, we'll just toss some money to the state. And the only remedy then would be to get a refund from the state taxing authorities. Am I correct in the analysis of remedies? I'm wrong.
I think a couple of things.
Yeah.
One, it's not just what I've said, it's what the New Jersey Tax Court, the New Jersey Court of Appeals, the
I've read the
Georgia
cases,
Court of
but-
Appeals have said that as well. Second, you've described a factual situation that's simply not applied. We're not talking about a rogue retailer. We're not talking about somebody that's charging 9% sales tax and only remitting 6%.
Let me put the hypothetical
Undisputed
to you
on the
then.
facts of this case
Yeah.
that we've charged 6%, we've sent the state everything we collected.
Then address the rogue retailer hypothetical, though. Supposing you had a rogue retailer who deliberately tacked on an extra percent under the business model of it's only 43 cents or 40, whatever, we'll get away with it. And if anybody raises a ruckus, we'll throw some money around. Under your theory, I take it if that rogue retailer tosses the money to Department of Revenue, there's no claim against a rogue retailer.
If they toss all of the money, I would say that's correct. If the rogue retailer is collecting more tax or the rogue retailer is not submitting it or remitting it to the state of Iowa, then I think the consumer may very well have a consumer fraud, or they may have a common law claim. That's not the instance before the court today.
If the retailer chooses the option under 2 doesn't do the safe harbor, doesn't do the interpleader, what I call by analogy, and hangs on to the money, then there may well be a cause of action.
I think there may well be a cause of action. That's not the situation before the court. JCPenney has collected the sales tax consistent with what it has been told in the various information that's received from the Department of Revenue. It's collected, it has remitted the entire amount to the state of Iowa. And I submit under the Streamlined Sales and Use Tax Act, once it has done that, the plaintiff or the consumer's exclusive remedy is to pursue the administrative refund process, which, as I pointed out before, works incredibly well, with 600 of 648 claims resolved informally.
You know, you use the word exclusive, and the cases do too, the New Jersey case and the Georgia case. They talk about the exclusive jurisdiction of taxing authorities. And there's no question that the 17A remedy is exclusive in terms of disputes with the state. But other than, I mean, you have a pragmatic argument saying the tax procedures are exclusive, but there's no statute that says it's exclusive when there's a dispute between a retailer and a taxpayer, I don't think.
Well, I think certainly as you read the Streamlined Sales and Use Tax Act, I think that's the clear, that's my understanding how I would read that particular act. And I think we're in the context.
What language suggests that the state remedies are exclusive? I mean, frankly, I just don't see it there. I understand your pragmatic argument that says, hey, look, they're the tax experts.
Well, I think
they
the
resolve
section
it.
that gives the retailer the option of either refunding the tax to the consumer or paying it over provides them a safe harbor, provides them that option. The plaintiff is the one that's trying to imply a private cause of action. They're the one that has to come forth and satisfy all the four elements of the standard that's been adopted by this court. And as Judge Paulson concluded at the district court level, they failed to fulfill and satisfy three of those four factors. And I think his analysis is very sound in that regard, particularly as in terms of interpreting the purpose of the act, and also in terms of how the exclusive jurisdiction of the Department of Revenue in this particular area. If the court were to allow an implied private cause of action, it's going to interfere with the Department of Revenue's exclusive jurisdiction over the assessment and collection of taxes. It's going to take an act that was supposed to be streamlined to minimize the burdens of the retailer and now subject them to small claims actions in 99 counties of Iowa, over 48 cents or so of taxes. It's difficult for me to square, in fact impossible for me to square, allowing a private cause of action with a statute that's enacted to simplify and streamline the tax process. And I think certainly the analysis of the courts that we've cited and the other authority that we've relied upon, I think clearly established that. We don't have the department here. I don't think that the court can speculate as to whether or not the department would intervene. They certainly have not to date. And I think the department, I think, looks at this and says, hey, we've got an administrative process in place. That's where this issue should be resolved. And they're not, I suspect they're not going to intervene in this case. If they were, they would have gotten here and been here before. And I don't think that the consumer taxpayer can circumvent the exclusive remedy of the administrative process just simply by recasting their claims in this particular case. So I think that Judge Paulson correctly looked at the issues. He examined them in the course of the initial motion for summary judgment. When plaintiffs sought to amend to add the common law claims, he addressed it in the context of the second motion for summary judgment. And I think the context of that summary judgment on the undisputed facts of the case are important and also resolve the other issues that plaintiffs have sought to argue in terms of the lump sum sales tax, which we really haven't talked about today, but I think are adequately addressed in the brief. J.C. Penney respectfully requests that the court affirm the decision of the district court and dismiss plaintiffs' claims in this case, all of them with prejudice. Thank you.
Thank you as well, counsel. Rebuttal argument?
Thank you, Your Honor. I want to initially reply to one of the questions that Justice Apple was asking Mr. Thrall, and he were talking about, cause of action suing the Department of Revenue. And I would point out that under Iowa Code Section 423.45, which is this chapter we're talking about today, subparagraph 6 states that by having this statute, this consumer claim to the retailer and the option to remit tax, all those kind of things, subparagraph 6 says that this is not creating any cause of action against the state. And we've interpreted that. It seems to be very clear when you read that okay, you have a claim procedure that's being set up, the 60-day notice to the retailer. You have give the retailer information so that they can respond. If they don't adequately respond, you could sue them after the 60 days. But in there it says no cause of action is created against the state. And so we believe, not even going into Tort Claims Act, but just talking about suing them under the Streamlined Sales and Use Tax Act, you can't do it.
Let me ask this question. say you're successful in your suit,
Correct. Okay.
and the district court orders a big refund, and then the Department of Revenue comes in a week later and says, well, does J.C. Penney make the refund when they don't have the money?
They would, yeah, they have the option of seeking the refund, yes, because they've already remitted the money.
So then
to
they
the
have to go back to the Department of Revenue and get the money.
Correct. Yeah, they wouldn't, I don't believe anything under the statute would make
But
them.
what procedure is there in the code or in the rules that allow them to go back to the Department of Revenue and get the money?
Iowa Code Section 423.47, which deals with refunds, they, not only does a person, when you talk about persons being entitled to refunds, under the definition of person, that not only includes Ms. Bass or any other Iowa consumer, but it also includes businesses like J.C. Penney's. And so they could file a request for refund
And
just like we can.
say they file the request for the refund,
Okay?
and say the Department of Revenue says, no, you're wrong on the law. Okay, and then the Department of Revenue brings a lawsuit. The ruling in your case, whether it's taxable or not, it's not binding in their lawsuit, is it?
I think it would give some precedential value.
But it's not binding.
It's not binding, no, because it would go through the administrative process. Whether,
District court, and then
Yep.
doesn't that put the retailer in a bad situation where they may end up paying the tax twice? I mean, if you win and they have to pay you back, and they lose with the Department of Revenue, I mean, isn't the whole purpose of this act to avoid something like that to happen?
well, I don't think they would have to pay it twice, because the purpose would be going through the
If
Department
they
of
have to pay you back, and then they can't get a refund back, they've paid the sales tax, not you.
Well, I don't necessarily agree that there wouldn't be any precedential value. If this court today says there is a cause of action, we go through the district court level, assuming the district court finds in our favor, maybe says no tax, we may be here again someday, but if
It's
we
not
then
the-
go through the refund
It's not
process.
binding on the Department of Revenue, there's no claim preclusion or issue preclusion, and they make tax or different things to present to us. It seems to me that if we allow your suit to go and you win, and the retailer can't get their money back from the Department of Revenue, they've just paid your tax. Because it's really not binding on the Department of Revenue what happens in your suit.
I guess it would depend upon how far the ruling goes. Because one of the issues the district court's going to have to interpret, which kind of also deals with a question or comment that Mr. Thrall made, was this concept of delivery charges and whether it's subject to sales tax or not, and whether, they claim the Department of Revenue has given them guidance. At this point, when you look at the statute talking about what shipping and handling is subject to delivery charge, it's that delivery charges that are separately stated, separately invoices, and that aren't part of the sales price. But the Department of Revenue on their internet posted, the guidance as a newsletter that says, delivery charges are exempt only if they're reasonable in amount and directly related to
But
transportation.
you can't even be sure that a court of last resort like our court would even hear that issue. I mean, it may end up district court, they may not appeal. They may appeal it, it may go to the Court of Appeals, and it may never be any precedential value in this state if we don't take it. If we take it, I don't know how we could say it's binding on the Department of Revenue.
And I understand your question. Yeah, I mean, if ultimately if the district court found in our favor on the issue and in the interpretation that delivery charges that are charged by JCPenney's in this case are not subject to sales tax, and therefore the plaintiffs and the class that whoever's all in the class are entitled to a refund. If they don't appeal that, yeah, that could be a non-precedential issue that then when you go through the refund process, you may have to litigate that again through the refund process. I think, but the problem that exists is the way that the statute is worded, the way that Iowa adopted the uniform statute, is it says that this cause of action is there. And I know the district court kind of, said, well, it's only contemplated, and therefore you got to go through the Marcus and Court analysis to determine whether one's implied. We don't necessarily even agree with that. We think that the statute is fairly clear when you look at it, because who else would have a cause of action over this excess tax? It talks about consumer rights. And, we're just asking the statute to be interpreted the way that it's written.
I think they're arguing, doesn't the payment to the Department of Revenue cut off that right, even though the statute may allow it?
Well, we believe the statute doesn't say that, because the problem with, if you go by the remittance issue and just say, Well, because they remitted the tax, you got to go through the Department of Revenue. Again, you've shifted the burden under the statute to taxpayers, and even the Department of Revenue. If the Department of Revenue gets flooded with thousands of refund applications over the same facts, that isn't necessarily going to stop JCPenney's from continuing to charge it.
Doesn't that help or solve Justice Apple's rogue tax collector that, you know, if you don't turn it over, you're gonna get sued. If you turn it over, you've cut off the cause of action between you and the Department of Revenue. So
Well,
that sort of takes care of his problem too.
Well, and I think, I mean, in a way, we have a bit of a rogue retailer now, because they were, you know, twice told by the Department of Revenue people that you can't do this, and if you think you can, you should ask for a revenue ruling. And they've had at least two consumer complaints that we're aware of, and they've refused to change it, and refused to do anything different, refused to get guidance. And if it's shifted just to where a taxpayer is going to do it, someone like Miss Bass, she may be the only person in a year that asks for a refund, they're going to keep doing it. I mean, it's right now, this has been going on, the law changed in '05, and this has been going on since 2005. A couple complaints, and that's happened in 2011. So for 6 years, nobody complained. Now we've had complaints, but the complaints are going unresolved, and that's why we think the statute clearly says there's a cause of action. We don't think you have to go through the analysis of Marcus in court to imply one, but if you go that route, we believe the court erred that all four factors weigh in favor of protecting consumers and allowing a cause of action.
Thank you, counsel.
Thank you, Your Honor.
The case is then submitted to the court, and we'll all hear the arguments in re the interest of J.C.